Hi, everyone. Welcome to today's IC Speaker Series talk. So today we have Professor Don Nunziato from Washington University Law School. Professor Nunziato is the co-director of the Ethical Technology Initiative and the Global Internet Freedom Project at GW Law. She is the chair of the U.S. TikTok Content Advisory Council and is the author of the critically acclaimed book, Virtual Freedom, Net Neutrality, and Free Speech in the Internet Age. And today she'll be giving a talk on the EU versus the platforms and the First Amendment. So take it away.
Hi, everyone. Can you hear me just fine in the back? Great. Thank you for having me. Thank you for the warm welcome. It's an honor to be back here at Yale to talk to you about some areas of my current research, which includes, this conflict between the EU's attempt to regulate the platforms, especially in the areas of hate speech and misinformation, and the platform's pushback and the United States' approach to this information itself, and also to the platforms and providing the immunity to the platforms for this sort of information. So we'll dive on in. I think my paper was maybe made available.
Yeah, the resident fellows received a copy.
Okay, and happy to make that more widely available and also to make the presentation available if that's helpful. It has a number of clickable links that provide more information. Okay, so this is what I think my thesis is, which is that, instead of the platforms being able to sort of vacillate and change with the wind on their terms of service and their terms of service regarding hate speech and misinformation, dominant platforms, and I'm focusing on X and Meta, should conform their hate speech content moderation practices to the international human rights law approach, to sort of balancing the right to free speech against protections against discriminatory, hateful speech. So I'll talk about that. And I'm not making any claims about whether the government should regulate hate speech. So we'll put that to one side. And if you'll remember from a few weeks ago, Pam Bondi talking about, regulating hate speech in the United States, we regulate hate speech. We don't, as I think you know, right? The hate speech, hateful speech is protected by the First Amendment. Misinformation is protected by the First Amendment. I'm not arguing that the government in the United States should regulate hate speech, but I am arguing that the dominant platforms should do so, in short. And just to get this out of the way, to distinguish between state regulation of hate speech and platform content moderation, there are a few important distinctions. One, content moderation of hate speech does not involve criminal penalties or civil penalties, right? What does it involve? Take the content down. You may have noticed or seen recently that a number of European governments are pretty actively and heavily regulating hate speech, and raids that Germany and other countries are arresting people for hateful speech, and that's controversial, right? And I'm not arguing for that. So we're not talking about civil or criminal penalties. We're just talking about take down the hateful content. I also would argue that platform content moderation of hateful speech is important and necessary to prevent the rapid amplification and virality of very harmful, hateful speech. And I'll talk about the instance of Facebook and the Rohingya Muslims in Myanmar. So real world harms that can come from this rapid amplification and virality of hate speech online. And then, in contrast to the First Amendment and the First Amendment theory of the marketplace of ideas and the default response to bad speech is good speech, right? That's how counter speech is supposed to work. in the marketplace of ideas, in our First Amendment theory. I mean, we all know that on platforms, we see echo chambers and we see information silos and less exposure to counter speech. So I would argue, and I don't really do so in this paper, but I would argue that counter speech is not effective, and the marketplace of ideas is not effective in countering harmful, hateful speech on many platforms. So for those three reasons, even if state government regulation of hate speech is unwarranted, I would argue that the platform's content moderation of hateful speech is warranted. And furthermore, doing so, having platforms moderate hate speech in this way, in conformance with international human rights law, would address these conflicts with the EU regulatory approach under the Digital Services Act, the DSA, and precursor regulations. So that's where I'm heading in this part of the talk. So just to sort of set the table a little bit, we know that after Net Choice v. Moody 2024 decision of the Supreme Court, that the platform's exercise of content curation and moderation is likely protected expression, right? That was in response to the Texas and Florida laws that were regulating the content moderation of the platforms. And we get this Moody decision, which says, hey, that is likely First Amendment protected expression on the part of the platforms. Okay, so First Amendment protection applies to the content moderation decisions of the platforms, and the Communications Decency Act, CDA 230, also immunizes the platforms for hosting harmful speech, hate speech, a whole bunch of types of lawful but awful but lawful speech. And we also know that in the United States, hate speech and misinformation is protected by the First Amendment. So basically, the platforms under US law, First Amendment, CDA 230, platforms can do whatever they want, right? So the question is, what should they do? How should they exercise this broad, vast discretion that they have to take down harmful content, keep it up, amplify it, monetize it, et cetera? Well, then, the EU law steps in, and now we have the Digital Services Act, the EU's Digital Services Act, which requires the platforms to take certain measures with respect to illegal hate speech as defined under European law, illegal hate speech, and regarding disinformation. Okay. And as I'll talk about, the EU has been in the business of regulating countries' approach to hate speech, hateful speech for some time now. Okay, so I'll turn to that now, but this is where I'm heading, is to sort of describe this global conflict between the US approach and the EU's approach. So just a quick background on the history of international and especially EU regulation of free expression, including on platforms. Right, so we have the International Covenant on Civil and Political Rights, the ICCPR, and the European Convention on Human Rights that provide, like the First Amendment does, provides protection for freedom of expression. But these documents especially balance the First Amendment, the free speech right, and limit it in order to advance and protect other rights. So expressly, the ICCPR Article 19 protection and the European Human Rights Article 10 protection is limited by other rights. In contrast to Congress shall make no law, right? Here we have this free speech right that's limited by the right to be free from discrimination. And Article 20 of the ICCPR expressly prohibits this advocacy of national or racial or religious hatred that constitutes an incitement to discrimination or an incitement to hatred. And then we also have the CERD, which requires that signatory countries punish expressions of racial discrimination. So that sounds very different to American ears, right? We don't have any law that requires the punishment of expression of racial discrimination. Quite the contrary, right? So that's these baseline protections from the 1950s, 1960s, international law and European law. Then in the past 10 or 20 years, the EU has taken even more targeted measures to address hate speech in general and hate speech online. So we see in 2008, we have this framework, the EU framework on combating racism and xenophobia, which requires countries in the EU to punish the public incitement. And note that language, it's not incitement to violence like Brandenburg, it's public incitement to hatred, right? So countries, EU member states must punish public incitement to hatred based on race, religion, national origin, etc. That's as of 2008. In 2011, note this, that the UN Guiding Principles on Business and Human Rights, the UNGP or the Ruggie framework, requires businesses and companies to adhere to international human rights standards. So not just the states, but also companies and businesses that operate to adhere to these international human rights standards, especially as set forth in the ICCPR. Okay, so that's 2008, 2011, stepping into regulating hate speech by member states and also by businesses that operate in this area. Then in 2016, we see the EU Code of Conduct on countering illegal hate speech online. Now, this was created as a voluntary framework where the platforms could sign on to, and they had sort of an incentive to sign on to this voluntary code of conduct. Why? Because in part because they wanted to avoid regulation. They wanted to avoid the Digital Services Act, which is what we have now. So the platforms, voluntarily sign on to this code of conduct. And in doing so, they make a commitment to agree to remove illegal hate speech on their platforms expeditiously within 24 hours of receiving notice of it. Okay, and that definition refers back to the 2008 framework decision. They didn't. The platforms, including then Twitter and then Facebook, they didn't do as well as the EU regulators wanted them to do in complying with this mandate of expeditiously removing hate speech within 24 hours. So instead of the voluntary framework under the EU Code of Conduct in 2016, we now have the Digital Services Act, which is a mandate, which is a regulation of the platforms. We also have in 2025 the revised. It's called the Code of Conduct Plus. If you look it up, it's called the Code of Conduct Plus, which builds on the 2016 EU Code of Conduct and is now incorporated in the Digital Services Act, which basically requires the same thing, requires the platforms to act on illegal hate speech within 24 hours of receiving notice of it. So if you think about the infrastructure that the social media platforms now have to have in place to do this, it's pretty extensive and pretty massive. But fortunately, they're massive too, right? So if anybody can do it, Meta and X presumably could set up a system like this where receive notice of illegal hate speech, act on it, figure out what to do, take it down or remove access to it within 24 hours. Okay, so this is all kind of leading up to 2023, 2024. The Digital Services Act now requires the platforms to do this, to expeditiously remove illegal speech, and I'm focusing on illegal hate speech, within a short period of time after receiving notice of it. And what is illegal hate speech? Well, if the speech is illegal under any of the member states' laws, then it's illegal hate speech under the Digital Services Act. And I'm going to be focusing on X's changes in hate speech regarding sexual orientation and gender identity, and Meta's as well. So I just point this out for us that 24 member states, hate speech on the basis of sexual orientation is illegal hate speech. And in 14, hate speech on the basis of gender identity and related definitions is illegal. Okay, so that's basically what we've just been discussing is the EU and international approach to regulating hate speech or requiring the countries to regulate hate speech. Now let's turn to what the platforms have been doing. The platforms have been all over the place. And that's part of my, honestly, that's part of my frustration, but also, part of my argument is that they shouldn't be all over the place. They shouldn't be vacillating and sort of, changing with the winds and with the tides. So we start, as you may, you may not remember, but you may have heard of Twitter back in 2012 referring to itself as the free speech wing of the free speech party, right? Like, let it all out there. Then around 2015 or so, we see this EU pressure on the platforms to do some more moderating of hate speech. And so we see a little bit more of that beginning around this time. And I just want to highlight this one incident of many, but this was a particularly extreme instance where, according to this UN fact-finding mission, and many experts, Facebook in 2017 and around that time played a significant role in ethnic conflicts and in the displacement and genocide of tens or hundreds of thousands of the Rohingya Muslims in Myanmar. By allowing hateful speech against the Rohingya to exist on platform, to remain on the platform, to be amplified, and not doing anything meaningful about it. Including, so this is sort of combines hate speech, and misinformation, right? A lot of times they're one and the same. Here we have misinformation seeded by the ruling military party in Myanmar, gets on the platform. Oh, and Facebook was basically, because of a zero rating approach, Facebook was the only provider of social media and internet in Myanmar at the time. So everyone's getting their information from Facebook, right? And this hateful misinformation against the Rohingya is available and remains on platform with little to no content moderation, in part because of challenges related to language, right? If you're going to be responsible for moderating hate speech and misinformation, you have to have expertise in all these different languages, right? All over the world, which is a huge, obligation. But, with great power comes great responsibility, as some famous character once said. And so this is a really derogation of this responsibility on the part of Facebook. This is some of the hateful language that was seeded and was made available on Facebook and was not moderated. And then, as I said, this language is in violation of Facebook's own then applicable terms of service or community guidelines, and they didn't act on it, and it stays on platform. And as I said, the UN fact-finding mission finds that Facebook played a role in contributing to, and the hate speech on Facebook, unmoderated, plays a role in the displacement and genocide of the Rohingya Muslims. So, not surprising that following this and in the same period of time, Facebook makes a commitment to have its content moderation practices informed by the ICCPR's balance and the UN guiding principles that apply to businesses. On this balance between, the benefits of free expression and the harms that can come from free expression. So Facebook and then Twitter CEOs commit to having their content moderation policies be informed and compliant with the ICCPR, UNGP, et cetera. And I'll just note that the same was true of Facebook's oversight board. Maybe you're familiar with the sort of Facebook Supreme Court, right? The Facebook Oversight Board, which first stood up and becomes active in 2020. And the Facebook Oversight Board's charter says that its decisions its speech decisions will conform, content moderation decisions will conform with and be guided by the ICCPR, by international human rights law. So we have this commitment from Facebook and also to a lesser extent from Twitter at this time to, tell us what to do, international human rights community. We will comply with these guidelines and these mandates. And then 2023, 2024, we have the DSA becoming effective. All right. But then in the past 3 years, we've seen the platforms really step away from these commitments to have their content moderation decisions be guided by international human rights law. We have Musk taking over Twitter. We have, Trump apparently threatening Zuckerberg with life imprisonment. On what grounds, I don't know, but threatening Zuckerberg with life imprisonment for Meta's content moderation decisions around January 6th, around COVID misinformation. And not surprisingly, we have Meta and X kind of changing their tune and lessening their commitment, let's say, to comply with international human rights laws on hate speech and other things. And then we see the platforms start complaining just around the same time as the Trump administration, second Trump administration, complaining about European censorship, right? They're the censorship industrial complex. They're just trying to tell us what to do. And we see Meta announcing major changes to its hate speech policies, right around January 2025. And I'll talk about some of those, bringing it a lot closer to where X has ended up in the past couple of years. In particular, in January, Meta announces changes to its content moderation policies and strategies, has carve-outs from its community standards to allow for dehumanizing speech about immigrants, about transgender individuals, et cetera, and drops its restrictions on speech that were previously considered harmful, including criticisms of immigrants, women, transgender people, people on the basis of their sexual orientation, et cetera. And I'll talk about those as well. And, you know, sorry to put this up so big on the screen there, but these types of posts prior to January 2025 were not allowed on Meta, would have been subject to content moderation on Meta. And after, or as of January 2025, they are expressly allowed on Meta. So we see this change on the type of hateful language that is now allowed on Facebook and Instagram. So what's Meta doing? We know that they've made these changes as of January, but they also appear to be trying to comply with the Digital Services Act and its mandate that they receive and act on hate speech as defined under EU member states laws. So look, if you go to their hateful conduct page, they say, hey, if you're a European user and you see hate speech on our platform, you know, you can submit a legal removal request. So, you know, click here. I tried, but they said I'm not a European user. You can submit a request to take down hateful speech under EU law. However, the EU regulators found that just last week that this was not an effective complaint system for flagging illegal content. So if you just take a look at what the EU regulators are doing, they're in attempting to enforce the Digital Services Act. They're saying, look, Meta, this is not sufficient as a process matter. Having this as your notice and takedown scheme is not compliant with the Digital Services Act. And as I'll talk about in a second, Meta and the platforms are subject to fines up to 6% of their global annual turnover for violation of the DSA. So maybe that's sufficient to get them to sort of pay attention. I mean, you won't be surprised to hear that hate speech has expanded in its prevalence on X in the past few years, including, you know, and this is just from 2022 to 2023, hate speech, in particular homophobic content, racist content, transphobic content has massively expanded on X under Musk, right? And the disbanding of the Twitter Trust and Safety Council, right? So with measures like these, hate speech has grown quite prevalent on X. And so we're seeing this really coming to a head of the conflict between the EU regulators and our platforms, our social media platforms in the United States. So the former digital commissioner, Thierry Breton, posts on X a letter to Musk about his concerns about the amplification and presence of illegal hate speech on X and the spillover to EU users. And you can see the letter, and Musk responds by tweeting this meme back at Breton, which says, "Take a big step back," and I won't repeat that language there. But that's the response to the EU regulator. Another response to a similar type of post from an EU regulator, Musk responded with just a poop emoji. Okay, so in that vein, right? That's the nature of the response from Musk on X. The European Commission has now initiated 14 proceedings against the platforms, not just X and Twitter, but I'm sorry, not just X and Meta, but others. for possible breaches of the Digital Services Act. And as I mentioned in the earlier slide, the commission concluded last week that Meta wasn't doing enough on this sort of notice and takedown mechanism to allow users to file complaints about illegal hate speech and other illegal content online. And this, this massive stick of a penalty of 6% of its global annual turnover. So, I mean, I think even if you're Musk and you're, the first $500 trillionaire or whatever, you might want to take this sort of stick seriously, right? 6% of your global annual turnover. So we'll see what happens with Meta and with X responding to the Digital Services Act mandates. And again, to sort of recap my thesis, we've seen over the past 10, 15 years, the platforms just sort of vacillating in their content moderation policies, like, oh, we'll allow all speech. We're the free speech wing of the free speech party, to, oh, we better do something about this hate speech on platform. It's causing all these serious real world harms. We'll pay attention. We'll comply with the ICCPR and EU hate speech regulation. Back to, stop telling us what to do. The censorship industrial complex, Trump, can you please save us from what the EU is making us do? And my argument is, look, the EU regulators and internationally under the ICCPR, it's been very carefully thought through, the balances between free speech benefits and harms. We have a very thoughtful, robust mechanism for addressing this balance, and complying with the EU regulatory approach would be in the platform's interests and would be in users' interests as well. And again, we're not talking about criminalizing hate speech. We're talking about platforms' voluntary content moderation of hate speech in a manner that is principled and consistent over time for users. Okay, so that's a part of my paper, or that is my paper's focus on content moderation of hate speech by the platforms. I thought if I have some time, I would also say a word or two, which is not in my paper, but a word or two about fact-checking and misinformation on platform, because I think this is also an interesting and important recent development. So in addition to the regulation of hate speech on the Digital Services Act regulation of hate speech, we also have a code of practice, an EU code of practice on disinformation that has been integrated into the Digital Services Act, and that requires large platforms and large search engines to basically take measures to address misinformation and disinformation on their platforms, and to address some of the systemic risks on their platforms, including from the spread of disinformation. We've seen the platforms pushing back on these obligations, the obligations to address mis and disinformation. So we've seen Google saying, we're not going to build fact-checking into our ranking systems and algorithms, despite the EU regulation. Google says this is simply not appropriate or effective for our services, and we're not going to do it. Okay, so now we've got Google in there stepping in to oppose the EU's efforts to regulate their treatment of mis and disinformation on platform. We also have, we're talking about this right before this lecture, that Meta, also as of January, all kinds of things happened with Meta in January, including Zuckerberg attending the inauguration, right? And Meta announces changes in its fact-checking policies that apply to the United States. So Meta had built up and has built up this very extensive fact-checking policy where it worked with independent fact-checking organizations to fact-check content on its platforms. This began after, lots of misinformation and disinformation in connection with the 2016 US election with Russian bots and on platform. Meta spent $100 million, sort of a drop in the bucket for them, but seems significant, $100 million on this fact-checking operation since 2016. So a very extensive fact-checking system that was in place. But then earlier this year in January, Meta says, we're stopping with the fact-checking, at least in the United States. We're not going to have the fact-checking program that we previously had, where we work with independent fact-checking organizations to check claims in posts. And some of the organizations that they worked with were like, AP, Associated Press, US News. This was a paid system whereby content on Meta could be referred to an independent fact checker, and then the fact checker gets to say false, misleading, true, partly false, et cetera, or satire, et cetera, and downrank the content when it's found to contain falsehoods. In January, Meta says, we're not doing this anymore in the United States. Bless you. We're going to replace our fact-checking program with a community notes type approach, a sort of, crowdsourced approach to fact-checking. A couple problems with this that we might see right away. One, even though they say that they're not ending fact-checking in other countries, there's going to be sort of drying up of financial resources, probably because of the cutting off of the fact-checking approach in the United States. So that may affect fact-checking in other countries. And two, with this community notes type approach, a lot of times we see community notes provide links to fact checks with the fact checks that have been done through the fact-checking program. So concerns about how the pulling out of the fact-checking program in the United States is going to affect fact-checking in the rest of the world, and how community notes are going to work without being able to refer to fact checks. So this is some of the language from Meta in January of 2025. We used to work with the this nonpartisan international fact-checking network, and we're not going to do that anymore. When we launched it, we made it clear that we didn't want to be the arbiters of truth, and we wanted to be unbiased, but that's not the way things played out, especially in the United States. The fact checkers were biased. We're concerned that the fact checkers were biased, and especially in the United States, and we're not going to do that anymore. Okay. This has turned into a tool for censorship in the United States. And again, this is in part because of, I think, because of some of the concerns raised by the Trump administration and the FCC about fact-checking in the United States, right? We're not going to do this anymore. We're changing our approach. We're going to take the approach that X takes to fact-checking, which is to rely on sort of crowdsourced community notes. And we can talk a little bit more about that. I think this is also in response to Brendan Carr, who's now chair of the FCC, who writes this letter back in November to Zuckerberg and to Cook and to others and says, we think your fact-checking, quote unquote fact-checking, is censorship, right? We think that your whole fact-checking mechanism is actually censorship. And this censorship cartel is an affront to our First Amendment freedoms and must be completely dismantled. And Zuckerberg's like, okay, less than 2 months later, we will completely dismantle our fact-checking system in the United States. right? Our democracy depends on freedom of expression, agreed. But I'm not sure that I agree that fact-checking equals censorship. Okay, so this is Carr's letter to the platforms: dismantle your fact-checking system, at least in the United States, and that's exactly what happened in January. Now, Meta says we're not going to dismantle our fact-checking, our working with independent, authoritative fact-checkers in other countries. We're not going to do that in Europe, perhaps as a nod to its obligations under the EU Code on Disinformation. Meta told regulators in Brazil, and Brazil has been another major global force in regulating the platforms. Meta told regulators in Brazil something similar, but many experts think that after dropping fact-checking in the United States, it's likely that Meta will drop its fact-checking approach in other countries as well. I'm not even going to go into all of the sort of conflicts between the Trump administration's freedom of speech approach and First Amendment approach and their actual actions. But one of the first executive orders out of the White House was that government censorship has to stop and that the platforms have to stop censoring content. So they have to stop moderating content in a way that arguably disadvantages conservative viewpoints. And that was the whole subject of the Texas legislation that makes its way up to the United States Supreme Court in the Mooney decision. Similar issues at stake in the jawboning, alleged jawboning by the Biden administration to try to get the platforms to take down COVID and election misinformation. So we've seen, this major culture war in the United States over whether content moderation is necessary and important, or whether it's biased and constitutes, illegitimate censorship. And again, it's not just the EU that's attempting to regulate the platforms on content moderation. Brazil is another key player in this area. And you may recall hearing about Brazil banning X about a year ago because Musk refused to comply with a court order and refused to block a series of far-right accounts. And X was actually banned in Brazil for a short period of time. And then after it was banned, Musk is like, okay, I'm listening now, right? What was that you said? And X's lawyers then agreed to block hate speech and disinformation and to comply with Brazil's law on the subject. So we've got the EU, we've got Brazil attempting to control how the platforms exercise their power. So just to sum up, major conflicts between how the platforms exercise their discretion that they enjoy under the First Amendment in the United States on moderating content. Right? Leave us alone. Let us do whatever we want. We've got a First Amendment right to moderate content or not moderate content. And CDA 230 immunizes us from any harms that result, right? That's the United States approach. And then the approach from other countries, and especially the EU, requiring that the platforms be responsible in moderating hateful speech and misinformation on their platform. So stay tuned. I'm sure that there are many things that I did not address fully to your satisfaction. So I welcome any questions or comments that you have. Thank you.
But if anyone wants to go first,
Please, Chinmay.
thank you. This is fascinating, and it must have taken a lot of work because it's a wide span of time and geography. So I dealt with parts of this, and I feel like it kind of almost like fits well with your argument. So I've written a paper which I'm happy to send to you about how the Myanmar situation
Oh, wow.
sort of precipitated the Facebook Oversight Board
Yeah.
and then kind of created a set of principles which apply to the deplatforming.
Yeah.
But I love that you've done the spectrum because in a sense what I'm seeing from your paper, it's like a return to zero.
Yeah, a return to zero.
Because this is what they started with we have a right to free speech and no one should be regulating us. And Jack Wolfkin has this triangle theory,
Yeah.
right, that platforms are responsive to state power, which I kind of modified in that paper to say that platforms are responsive to some states' power. And so my argument there was that the instant Germany and the UN and kind of powerful institutional actors started calling Facebook out for Myanmar, that was the point at which Facebook was like, oh my God, we can't believe we did this. And we need better systems. And it kind of led to this like creation of this like institutionalizing, including the oversight board. And this is like a side note, not super important, but actually it fits your critique if you feel that this is true too. Well, I don't think that the oversight board adopts international human rights. It's sort of set up and like all of the narrative towards it was, yeah, that's our kind of international human rights body. But actually what they commit to is Facebook values and Facebook communities, which is much more plastic. And which kind of enables these spaces and policy, which again, like fits your argument actually of like the way in which tech companies kind of backed down and like switched. And so I'm kind of interested in how far you think Europe is able to exercise its state institutional power, as opposed to this kind of reversal in the US that companies to be like, okay, now we don't need to spend money on content moderation.
Right. I mean, my thought is that the EU approach is going to be powerful and is going to affect what the platforms do. I mean, I think that if we go back to the 2016 Code of Conduct, which was just voluntary, quote unquote voluntary, I think we saw the platforms really taking measures in response to the EU Code of Conduct and making significant changes to their content moderation to be able to take down hate speech, maybe not an illegal hate speech and other illegal content, maybe not as quickly as they were required to, but that whole sort of infrastructure and mechanism was stood up in compliance with the EU Code of Conduct. That's my understanding. And of course, we also had national laws like the NetzDG law in Germany, which said, here's a whole bunch of stuff that you need to take down and you need to do it expeditiously within 24 hours. And we don't think you're doing that, right? So my sense is that the platforms kind of instituted this infrastructure in 2016 and that it's still there in response to, at least in response to the EU's, powerful regulatory approach. But I would also love to talk more about the Facebook Oversight Board and how it actually makes its decisions and how, what it's guided by and what is it sort of voice, right? The Facebook value of voice, what does that mean? And how consistent is that with the ICCPR's protections for freedom of expression? In my paper, I discuss one or two Facebook Oversight Board decisions on hate speech content, and I think I'm actually really impressed with the depth of the analysis of the Facebook Oversight Board decisions. So I'd love to continue to talk about that.
I have two questions.
Yes.
First, You're making a normative statement about like how platforms should adhere to these international principles for like content moderation. And I wonder like what the enforcement structures could be in the United States, since it seems to me at least that like any legislation like imposing that somehow would be deemed unconstitutional because hate speech is a protected form of speech. And the second thing I was gonna ask, it might not be very appropriate, you might not want to answer.
Well, let me answer the first part first, which is, let me go back to, I mean, this is how Meta appears to be complying with the Digital Services Act on this notice and takedown, required notice and takedown of illegal content that's illegal in an EU member state,
Yes.
right? So it's not the United States that is intervening to require the platforms to do this. It's not. So I don't think that there are any First Amendment implications yet, right? Because it's just the EU saying, you operate in the EU, this is what you need to do. You need to have a user-friendly mechanism, which this is not, according to the regulators. You need to have a user-friendly mechanism of allowing people to flag illegal hate speech content. And then you need to act on it within, expeditiously. You need to act on this illegal hate speech content. And if you don't have a system whereby you effectively do that, then we're going to punish you. We're going to punish you by these massive fines. So that's the EU directly regulating the platforms that operate in the EU. So there's, even if having this mandate from the United States would violate the First Amendment and would be inconsistent with CDA 230, which it would, the United States as a state actor is not involved. Does that answer your question, or?
No, I don't understand how they could apply that for the jurisdiction of the United States, because I think, bear with me because I'm an international, if one were to try to revert the CDA 230, there's a First Amendment argument there that would be unconstitutional, right? If you were to penalize platforms for not removing content that is protected, so you could argue that that law would be unconstitutional. So in the United States, they wouldn't be able to do a DSA provision.
Correct.
Right?
Correct.
So what can you guys do? Like, what can you guys do? Because anything would be deemed unconstitutional.
So who's you guys?
You, United States.
Yeah, but the United States is not involved in enforcing the Digital Services Act.
Voluntary adherence by the private companies,
right,
to the international standards. No enforcement, no state enforcement.
Not by the United States.
Okay, by the other jurisdictions.
Yeah, by the other jurisdictions. I mean, and we'd have to get into sort of choice of law type discussion, international choice of law and enforcement. But as of right now, I think that the EU regulators could say, X, you operate massively in Europe, Meta, you do as well. We can fine you. We can fine you up to 6% of your global annual turnover for not complying with our law. And we can, if it went this far, we could arrest your agents who are operating, your employees who are operating in Europe. We saw something like this way back when in the Yahoo Lycra hate speech decision back in, maybe you can help me with this, Chinmaya. Do you remember the
1997 or 8?
1997, we saw Yahoo, an auction site that Yahoo operated, had for auction Nazi memorabilia. and that was operating, internationally. And Yahoo was operating in France, and France says, allowing for this auction of Nazi memorabilia violates our laws. So we're going to require that you stop hosting this Nazi memorabilia on your auction site, or we're going to, enforce this. So if we go back to the Yahoo France decision in the late 1990s, we see some very interesting personal jurisdiction and choice of law decisions where the U.S. government was involved in enforcing that French law against a U.S. company. And after 10 years of litigation, I think we got like no answer on that because of lack of standing. But I think those are the sorts of issues that your question raises, is what about if the United States government was called on to, intervene in the enforcement of the Digital Services Act?
You wrote a paper on this, didn't you? I feel like I cited you.
Probably. It's been a long time. It's been 25 or so years since all that. But I think that that the EU regulators can enforce the Digital Services Act's obligations without the necessity of getting the US government involved, which would arguably implicate the First Amendment. And they can just directly fine Musk and Zuckerberg and X and Meta because they have operations directly in Europe. And this is not really my field, but that's my understanding, is that because they're operational in Europe, they can reach out and find them directly. Let me take another question.
Thank you for the presentation. My question is about alternatives to takedown. So in the section of your talk, it seemed like you were quite focused on takedown, probably because it aligns with the international and EU law. But I'm wondering if you could defend it against other kinds of alternatives, like algorithmic deprioritization, shadow banning, like karmic rules of visibility, where like the people with low user karma like see each other and like other people see themselves. Just because like those would be like a softer request.
Right.
So I'm wondering like, why did you jump straight to takedown, and like could you defend that?
Yeah, so the question, I don't know if you heard it, but the question is why just focus on takedown of the hateful content? Why not other sort of softer means of deprioritizing this sort of content? Yeah, or allowing for counter speech, and particularly maybe for non-European audiences as well. Yeah, just for simplicity's sake, I think I'm focusing on takedown, and also because that's what the Digital Services Act requires, right? The Digital Services Act requires the taking down or disabling access to the content. So I guess there's a way in which this would be more complicated, but the platforms could disable access by European users to illegal hate speech content, but still allow it or allow certain other audiences to have access to it. This also, and I think that's a fine point. That's a good point, and I'll think about that. This also makes me think about the GDPR, right? The General Data Protection Regulation, and the rights of privacy that EU law has also mandated, right? Like for which audiences, right? Delisting for whom? So you could argue, well, a softer approach would be, instead of taking down the content, to deprioritize it, to have limited audience access to it, et cetera. And those would be more speech protective approaches. I think the major concern for the EU regulators is certainly the virality and amplification of illegal, harmful hate speech content and misinformation. So addressing the monetization and virality is the most important part. Yes, Caleb.
Oh, thanks. Yeah, thanks for the talk. It's really interesting. So I have a question about sort of the model of applying ICCPR and other international rights norms as kind of like a guide to platform moderation, content moderation. And I think so. My question is so obviously the ICCPR, or the Convention for the Elimination of All Forms of Racial Discrimination, sort of like the First Amendment, that they really apply to states, right? It's the states parties that incur the international obligation and the treaties. And like I understand that, I think you went through these guidelines which suggest extending them to businesses, and in this case, platforms. And obviously, people have written a lot about how platforms are kind of like government, like the kind of governing speech. But I wonder if there's a need for any kind of like modification, or like like if there's any gap between norms that would be appropriate for like a state actor versus like a platform that is governing speech but is not a state actor. And the example actually of disinformation, I think, is a helpful one, because I'm very comfortable with the idea that platforms should be required to take down or deprioritize false disinformation. But I think I'm not sure that I assume that international human rights norms don't require states to sort of like, or maybe even permit states to like punish just spreading false information, right? I mean, maybe like if there's like some kind of sign to require, so maybe like, you can think of a law that says like, you can't spread false information, but there probably has to be some kind of like intent to deceive. And I think I would be very uncomfortable with a law that's like that is imposed by a state that says like, as long as you're spreading false information, you can be penalized or something. So I wonder if there's any kind of, if you have any thoughts on how these norms that in the first instance are applicable to states, if they have to be sort of modified in some way to, in their sort of application to platforms.
I mean, and you mean also beyond the fact that the state has the power, the state is the unique source of penalizing and criminalizing content.
Yeah.
Right. Yeah. So I think that's a great question. And so thinking about the ways in which these requirements need to be sort of, or could be modified or transposed when they apply to platforms as governors, as opposed to the actual state as government. And I think it would also be helpful for us to look in greater detail at the UNGP, the UN guiding principles on this, because that's UN guiding principles on business and human rights. So that applies to states, but also to companies. And so I will take a look back at that and see how the Ruggie principles distinguish between businesses as exercising this power and states as exercising this power. I think that's a really important point. Thank you. Yes.
Thank you so much for this talk. It was really interesting.
Thank you.
I've been reading way too many policies as well, mostly from the platforms themselves, like self-governance documents.
Yeah.
And it seems that they're much more likely to define certain types of content that they're going to demonetize or kick off the platform, like hate speech, and much less eager to define, for example, disinformation. And one of the reasons for why that might be is also the kind of cyber libertarian roots of keeping things vague enough so that you can kind of like walk around them, right? And in the European tech space, there has been a lot of talk about having European technologies, European platforms, right? Because from the one hand, if you're going to create a company in the Silicon Valley in the 80s or 90s, where there don't seem to be too many rules governing you, there's little legal or also ideological scaffolding to keep these values alive. So I think going back to your question, I'm sorry, I don't know your name. Nice to meet you. Going back to your question, I think that there is a real question of, can external forces like the EU that are trying so hard to bring this kind of legal scaffolding to these platforms, will they manage to do so? But more importantly, what kind of other scaffolding can be created to keep companies like this accountable? Because they're not only companies anymore, really. They're more like, they're structuring the way that we also connect and behave, and it structures sociality. So are there also other type of laws that can be governing this instead of only like the ones that you've mentioned today?
Other sources of laws or other types of laws?
I guess also legal infrastructure is much more like, broadly speaking, what can be brought in to create accountability structures within the United States instead of looking outside for a state that will save us.
Yeah, and we've also were talking earlier about the reporting mechanisms and transparency and disclosure mechanisms. There were a spate of proposed federal legislation in the United States that would have attempted to impose these sort of transparency and disclosure requirements on the platforms. You have things like the PACT Act and other similar laws that would require the platforms to just disclose, just sort of publicly disclose what they're doing as far as moderating content. So the transparency and disclosure regimes, which the platforms are pretty much voluntarily complying with or had been voluntarily agreeing to just make available in their transparency reporting. So that's something that's not a US federal law, but it was a sort of threatened, proposed federal legislation. And the platforms basically got into the pattern of these, transparency requirements. So you might say that's some help to sort of look inside the black box and see what they are doing. But I don't think that goes far enough. And I think that X has been sort of falling down on its own promises with respect to transparency reporting. There's also California, right? I mean, California has been extremely active in recent years and currently in attempting to regulate the platforms in sort of a European style approach. And that, of course, California's laws are subject to the First Amendment, right? So we see California recently try to regulate deepfakes, political deepfakes, right? Struck down as violative of the First Amendment. We see California privacy regulation that has been enforced and upheld and enforced over the past number of years, that's sort of modeled I think along the lines of the European privacy regulation, the GDPR. So California has been a major force in regulating the platforms, regulating the platforms and targeted advertising to minors, right? Social media access by minors. And again, all of that would be have to conform with the First Amendment and be tested against the First Amendment. But I think there are a number of instances in which California has been at the forefront of this sort of regulation on a sort of a European style approach to regulating the platforms. Yes.
Inappropriate question.
Oh, yes. Your second inappropriate question.
I actually wanted to say also Brazilian.
Oh, right.
And the Supreme Court of Brazil has recently, I think in July, they were debating about exactly the Brazilian equivalent of CDA.
Yes.
30, and they created more forms of unprotected speech. And one of those versions, let's say, is speech that is incitement against the democratic state. So,
and this is the Brazilian Supreme Court that is creating new definitions of illegal content.
Yes,
right? As opposed to the legislature doing so.
which is something that we can't talk about because like within the rules of the game, like we can't say, oh, the Supreme Court should do this or that. Well, they will do whatever they find to be correct. But this might be a way that one could try and you know?
So it's really interesting to contrast the EU Digital Services Act approach, which is if the member states' countries' legislatures determine that this is illegal content, then the Digital Services Act would require the platforms to take it down. But that would be a legislative function, in contrast to my understanding of what Brazil is doing, which is, as you say, the Brazilian Supreme Court itself is defining new categories of illegal content and then would require the platforms to act on it.
Well, the SCOTUS could create more doctrine on unprotected forms of speech, would then allow Congress to pass law that obligates the companies to
Yeah,
do that moderation. Because then it's unprotected, then it's okay. Then the law could tell them to block it or to remove it, etc. Which is what is being done in Brazil.
yeah, and as we were saying, Brazil is a big player in this area. And Brazil recently had these conflicts with X and with Musk. And initially Musk was just like, I don't have to listen to you. We're going to do whatever we want. And then when X is banned in Brazil, that's a big deal, right? And then Musk is like, okay, come again. What do you want me to do? Right. So we're not just focusing on what the EU is doing. I'm also focusing on what especially Brazil and some other countries in South America, what they're doing in kind of modeling approaches on the Digital Services Act. So the DSA has been influential in its approach in other countries as well. Yes.
I want to raise 2 points for your paper. One is at the beginning when you were talking about the varieties of ways that both firms, the varieties of ways they're responding, and then within the same firm, how from year to year they were different in their regulations. I understood you to be presenting that as a negative thing in itself, but I'm curious if you're open to alternative explanations, such as, obviously the election, a huge business side impact on what a firm is willing to stick its neck out on. And,
right.
This obviously represents a much broader social phenomenon. And now these views that would have been considered hate speech under the Biden admin are now on TV, are now in legislation and being enacted across the country. So it's kind of an outdated term on one hand.
Mm-hmm.
And then on the other hand, this recent phenomenon that we've been seeing of this kind of weaponization and twisting of the concept of hate speech, especially after the murder of Charlie Kirk, how anybody who said anything about it is getting put on a list. And so all these subversive techniques to kind of weaponize hate speech. So those are the 2 concerns that I have with the concept, and I'd love to hear your
Thank you. Yeah. And I presented this paper a few weeks ago, and it just happened to be right around the same time that we had all of these conflicts around the people posting and speaking about the assassination of Charlie Kirk, and Pam Bondi talking about, hate speech and the weaponization of hate speech. And I was just like, this is a bad time to be, advocating for the removal of what somebody determines to be hate speech. I mean, is an important point, I think. And I think that, one of the things I would like to think more about with you all is whether consistency on the part of the platforms in content moderation, whether that in and of itself is a value or not. I mean, I find it frustrating to see, as I said, so many changes, political, changes on the part of the platform's ownership and in terms of their changes in their content moderation policies. As I was pointing out, just as of, I don't have it right here, but as of January, right, this is illegal on platform, right? This is not permitted on platform. In December, it would have, these posts would have been taken down. As of January, it gets to be kept up. And part of Zuckerberg's explanation is, hey, people in the halls of Congress are saying things like this, so why shouldn't we allow it on platform? And I think that maybe a response to that would be Facebook is a place that has its own values, has its own values of sort of community and voice. But if I'm just looking at what you're saying about the Facebook Oversight Board, and that community on social media means protecting people from hateful speech that would silence them. That's different from, the public town square and the marketplace of ideas and uninhibited, robust, wide open, vitriolic speech that we protect in the United States under the First Amendment. But, if I ruled the platforms, I think I would say community is important, voice is important. The way we are going to balance both of those important values is by having very careful, detailed definitions of what is dehumanizing, hateful speech, and not wavering on those definitions. So comparing, and I have this set out in the paper, but comparing people based on their race to unsavory animals, right? Or sort of Muslims are vermin, Muslims are rats, Muslims are invaders, whatever. If you look at Meta's definitions of illegal dehumanizing speech as of 2022 or whatever, that carefully detailed definition says that you cannot post, right? You cannot say, immigrants are garbage. You cannot say Black people are, apes. You cannot say Jewish people are rats. They have very clear, detailed definitions of what is illegal hate speech that is subject to, content moderation. I think that is different from, Pam Bondi saying, oh, what Jimmy Kimmel said was hate speech. That's not manipulable in the same sort of way. If we look at what Meta and formerly, Twitter had done in their very detailed community guidelines type information, was very, very detailed, well thought out, careful, specific definitions of what could be said and what could not be posted on platform, comparing someone based on this characteristic to someone who had to animals that are not desirable. So I think I would prefer an approach that is much more consistent throughout time on those values on the part of the platforms, and not just like, oh, what does the administration think about transgender people? Oh, let's just make some quick changes to our content moderation policy so we can stay in good with the current administration. It's about that time.
About that time. I hate having to do this, but thank you for the wonderful talk, for
It's my pleasure.
braving the terrible flight that got delayed a lot from DC to give us this presentation, and for your very thoughtful.
Thank you all for having me.